My name is James Krupke. I'm an attorney with the law firm of Ginarte, Dwyer, González, Gallardo, and Winograd. I have posted today to our website, ginarte.com, a blog post regarding an act of God defense. If you're interested in this subject, I encourage you to read our blog post. Essentially, in a personal injury case, it goes without saying that you must prove that some other party was negligent in causing your injuries. It's not sufficient to just say I was injured on somebody's property. You have to also prove that someone either did something they shouldn't have done or didn't do something that they should have done. A defense that sometimes comes up in accidents of these types is the act of God defense. And this is basically defined as an unusual, extraordinary, and unexpected manifestation of the forces of nature. So essentially, an example would be if you're in a car accident with someone and the other driver, through no fault of his own, has a seizure or passes out and strikes your car, injuring you, that person would have an act of God defense. Basically, they would state that it wasn't their negligence that caused your injuries, it was an act of God. This defense would not be applicable, however, in a situation where the person who strikes you either knew or should have known that he was subject to seizures or possibly passing out while operating an automobile. Under those facts, when you combine an act of God with a person's negligence, the act of God defense does not prevent liability on behalf of the defendant. This is a relatively rare defense, but it does come up sometimes. We here at Ginarte Dwyer handle these personal injury cases all the time. We're very familiar with these defenses, and our clients are in very good hands when it comes to these types of cases. If you have any questions, you can feel free to contact us. And you can also feel free to read the rest of my blog post. Thank you.